Well, I'm sure when you look at buying a car, you might wonder what happens to the finance of it if you find you have to return it. So imagine this, you go off, you find the car, you're very excited, you sign a long-term loan agreement, so you sign the finance with whoever. You take the car home, and over the next couple of days, you realize it's what's the polite phrase? A lemon. Skadonk, not going to work out. And you take it back. And what happens after that? Well, there was a case about this in the Supreme Court of Appeal. Fortune Cheho is an attorney at Trudie Broekmann Attorneys. Fortune, good evening. Really appreciate your time. Thank you. So this happened to Busisiwe Baloyi. She had the car for 4 days. She realized it was just hopeless. She went to the dealership to cancel the sale. She had taken out financing. And what happened after that? Because the financer, I think it was Westbank, wasn't it? What did they try to do?
Good evening, Stephen, to you and the listeners. Thank you for having me on the show. So yes, Ms. Busisiwe Baloyi purchased the vehicle and it was financed by Absa Bank, actually. It was financed by Absa Bank Limited, and shortly after taking delivery of the vehicle 2 days later, she discovered that the vehicle has a lot of issues. Those issues indicate problems with the gearbox, engine, as well as the electronics of the vehicle. And over and above that, she found out that the vehicle was actually involved in an accident and was reported as accident damaged. So obviously and understandably shocked, she took the vehicle back to the dealership and demanded that they cancel the installment sale agreement between her and the bank, and for her to be refunded her deposit that she paid, as well as the installments that she paid towards the financing of the vehicle to the bank. The dealership didn't honor her demands, and as a result thereof, Absa Bank Limited proceeded to institute action against her in the Johannesburg High Court. They issued summons against her, claiming for payment of the total cost of the credit, which is over 500,000 rand.
So just to understand, sorry to interrupt, Fortune. So she didn't have the car, so she did not have the use of the car. She had returned that.
Yes.
But had the dealership not returned the money to the bank?
No. So which is why this matter is particularly interesting, because unfortunately for Ms. Baloyi, this all happened before the Van Niekerk judgment, the Van Niekerk versus FirstRand Bank Limited judgment in the Supreme Court of Appeals, wherein the court clarified and confirmed that banks which finance vehicles are deemed to be suppliers of those vehicles for purposes of the Consumer Protection Act as well as the common law. So in terms of that judgment, if you have a defective vehicle that is financed by the bank, then your claim doesn't lie with the dealership, but the claim lies with the bank. You have the right to return the vehicle, of course, claim for cancellation of the installment sale agreement, and be refunded everything that you paid to the bank. So that includes the deposit as well as the monthly installments paid. So for that reason, the dealership didn't honor Ms. Baloyi's demands. They simply accepted the vehicle, and she received no feedback after that. She only got any sort of feedback or correspondence from the financier once they instituted action against her in the Johannesburg High Court, again claiming for payment of the total cost of the credit, which is over 500,000 rand.
Sure. So this goes to court, and there was the Van Niekerk judgment, and what did that change? Well, I mean, what happened in the end with Busisiwe Baloyi?
So what happened with Busisiwe Baloyi, because the judgment that was issued against her was issued in October 2025, which was 2 months before the Van Niekerk judgment, which was handed out in December 2025. So after coming across Busisiwe Baloyi's story and having read an article posted about her in the media, we asked that she contact us, and she reached out to us. And we've now stepped in. To clarify the position and wrote a strongly worded letter of demand to ABSA, clarifying the legal position insofar as it has been confirmed by the Niekerk judgment in the Supreme Court of Appeal, clarifying that because the vehicle was financed by ABSA and because the vehicle was defective, Ms. Busisiwe Baloyi was in fact the one that was entitled to cancel the agreement and be refunded the deposit as well as the installments paid. So we have done that, like I said, in a strongly worded letter of demand and are corresponding with ABSA Bank in order to get joy for Ms. Busisiwe Baloyi. So to rescind the judgment and for her to get her deposit as well as the installments paid to the financier.
I mean, ABSA might well say, well, look, we won, we did all of this in good faith. I mean, I can imagine all sorts of things they might say. It must happen, Fortune, I mean, you're an attorney in this space, that people get caught in the cracks, and this sort of happened to Busisiwe Baloyi here because the judgment just came a little later.
So that is essentially why it's very important to speak on this, because just like in Busisiwe Baloyi's case, the fact that even though the judgment came later and even if there is a judgment, one does still have the option of having the judgment rescinded on the grounds that there has been a judgment of the Supreme Court of Appeals clarifying that the banks are actually the suppliers and are liable when a vehicle that they finance is defective. So every other consumer out there who finds themselves in a similar situation to that of Busisiwe Baloyi can definitely reach out to us because they have that right. They have that right. The Niekerk judgment has clarified it, and there is nothing stopping them from approaching us so that we may step in to get some joy for them.
Fortune Shechop, thanks so much. Attorney at Trudie Broekmann Attorneys. What an interesting case. I mean, imagine being the person who gets stuck between these two judgments.